Hit them all at each other.
We target a place so we can,
Once the park closes,
it's not bad.
Well, you could build a pickleball.
Yeah,
Just ride it.
get on.
We can put that on the table. That's quiet.
It makes those people down there real happy.
Hey, turn the storage shed.
I think it should be a roof one.
You have a dome pickleball, oh God,
With lights.
all James Island.
Oh, we got that now.
Aaron, you ready?
I'm ready when
You got 2 hours of, you get your voice classes in today?
Yeah. That's it.
You know what I mean? And I was just, do your homework and get it done.
Actually got the clock synchronized out of
I don't know if we do or not, do we?
it. A couple seconds off.
Depends on whose clock you're looking for.
Mine just turned 5.
Okay, go ahead.
All right. Okay. So, welcome to STR work session. I'm gonna go ahead and christen this an annual STR work session for the time being. I know last year in the winter, we spent October through January essentially reviewing the STR ordinance and making some tweaks to make it better match our implementation and to work in some unique situations that have come up. And we're back again, winter 2024. We've had another full business license year of renewals, a full year of renewals for winter registrations, and we continue to get new and novel questions, some of them that are, easily fit into the framework of the existing ordinance, and some of them that require the ordinance to be adjusted, just to make sure that we're on sound legal footing moving forward as we implement our interpretation and administration of the ordinance. So that's what I hope to
For a little
talk about
while
in the
here.
next hour and a half to 2 hours with you guys. I'm going to start with the wait list update. And that's on the second page of the presentation. Phase one of the wait list phase one of the wait list was finalized on October 1st. That list has been published on the internet. It's on the STR wait list page on the City of Folly Beach. For those of you who haven't visited the STR section of the website recently, it now has a full timeline of all meetings related to STR, the wait list, a summary of enforcement actions that includes a live worksheet that's updated monthly to reflect all warnings, tickets, and dispositions. And we also have a section, those are the main ones. So the STR section of the website should answer everyone's questions about STRs. If you go there and you see something that's missing, please let us know, but we're trying to make it as informative and transparent as possible. 152 folks made it to the first phase of the wait list. I believe the earliest ownership date was 1978, running all the way through just a couple months before the referendum. Anyone on that list who is convicted of renting without a license will be removed from the list. We have a couple of cases in progress. Folks who have been cited for renting without a license, who may be coming off the list, but it's less than a handful, so there's not going to be any substantive movement of the list so far. No licenses are currently available under the cap, and we don't have a long history to really establish an attrition rate, but based on this year, we don't expect any licenses to be available until the end of renewal season next year at a minimum, and that's just a possibility. So phase one is going, it's happening, it's finalized, it's available for public review. Phase two is active, we're accepting entries. Last week when I ran the report to write my memo, we had 15 folks on phase two. So altogether we have about 167 people signed up for a short-term rental license when they become available. Phase two, we're going to try to update it every other month or so. Licenses are awarded in the order you apply, but because there's no timely need for it to be updated on a daily basis, we're just going to update it regularly, but it won't be as often as, say, the enforcement page. So that's the current status of the wait list. Anybody have any questions? moves right into the STR ordinance amendments. We've got this presentation where I'm going to hit what I consider to be the highlights. The memo goes into a little more detail, kind of listing every single change on here. They're not all in this presentation. If they're not in this presentation, it's because I consider them to be so minor they don't affect the function of the ordinance in any way. They're just clarifying language, etc. So if there's anything in the ordinance that I don't talk about in the presentation, it's on this list or in the ordinance, if you have a question about, please let me know. I am not going to read the entire list from the memo, but I just wanted to announce that there are a lot of small edits to the language just to make sentences clearer, more assertive. There's some structural changes that reorganizes the information. We're not really going to cover those tonight unless anyone has a question. So, kind of in order as these appear in the ordinance, we've combined all the references to agent, local agent, responsible agent that are scattered throughout the ordinance and come up with a definition of designated local agent. Your designated local agent is the person you put on the rental registration who, through applying for a rental registration, certifies that they will run that business according to the law and that they can be held responsible for violations of the ordinance. We ask for that information when you apply. We ask you to sign a piece of paper certifying that you understand that by naming someone agent, they're agreeing to share responsibility. They have some tasks they have to do, like respond in case of emergency, renew the license, renew the rental registration, that sort of thing. So we just took all the references to agent, and now we just say designated local agent throughout. An important thing to note here, the last sentence, the designated local agent may be cited and serve notice for violations under this ordinance. Some tickets, basically any ticket that the owner can get, the agent can receive on behalf of the owner. And so we put that in the definition, we put that in the certifications just to make it abundantly clear that agents are also responsible.
We ask questions now. So essentially, in simplest terms, it's a shared responsibility.
Yes.
Okay, so if a violation happens, whoever shares it, it's based on that property.
Right. Yes, ma'am. And, yes. I was gonna say something.
Right, you answered. It's good, it's all
Oh,
good.
yeah, I do know. That's if you name, you don't have to name a local agent, you can name yourself as a local agent and you're assuming full responsibility. But if you choose to name a local agent, this is what they do and they're responsible. All right, next up is a proof of the minimum nights rented. Last year, we put in a minimum night rental or minimum rental night requirement for STR licenses. That will come up for the first time during renewals next year in 2025. We will look back at the 2024 rental period and ask folks to prove that they have rented the property for at least 28 nights. We did tweak this a little bit, first to make sure that it only applies to ISTR licenses. ISTR licenses are capped. They can be lost, and once they're lost, they're gone, but for the wait list. OSTR licenses, there's no need to penalize an OSTR license for not renting the minimum nights, because if you take it away, the owners are still eligible for an OSTR. There's no limit on those licenses, so there's no need to remove them through attrition. If they're inactive, they're just inactive. So we clarified that the 28 minimum will only be applied to ISTR licenses. And for proof, we've been asked several times, what paperwork do I need to prepare next year to prove that I did this? And so we're going to ask for copies of fully executed rental contracts with receipts of payment for at least 28 nights. That's not for it. We're not asking that for every night you rented, just 28 nights. So if you can give us 28 nights of paperwork, we're going to consider you to meet that requirement, and we're going to move on. So that's the proof of the minimum nights rented. One more back, Wes. And also down on number 3, obviously the minimum nights is not applicable to a property that's being licensed for the first time, or for a new license that's given to a previously licensed property but by a new owner. If someone inherits a property and gets a new license, or they come off the wait list and get some new license, they have a full year from the time they assume ownership and management of the property to rent 28 nights.
That should cover properties that need to advertise for the following year, because you have to get your license to advertise.
Right.
So it gives a year for people to gear up, advertise before they actually start renting.
Right, yes, sir. So that's meant to just make it clear, because this is a question we were asked and the ordinance isn't clear now, that if I just got my license, I'm not responsible for what happened the year before. I'm responsible for my first year of ownership and full.
With the exception of that first year.
Well, at the end of your first year, you'll be asked to prove that you had 28 nights, but you're not.
The second year.
Yeah. At the end of
You
your
gotta
first
ramp
year,
it
which
up.
is the beginning of your second year.
So, let's just say someone was to get their rental license January 1st, and no STR, and they're gonna rent for 72 days. They can't advertise those 72 days that might start in June, July, August, but their license is gonna run out before then. So, the first year, all they're gonna be doing is advertising
Right.
by law.
But it doesn't apply to OSTR, correct?
Yeah, but you bring up a good point.
Yeah.
So if an ISTR gets its first license
In January.
on May 28th, the business license, and so I think we can add some language on second reading to say if the license was obtained within 3 months of the business, and, you know, you're correct. If someone
Even
gets-
still,
Yeah,
if someone's plan is to rent 4 months out of the summer, before they start advertising, they have to get a license.
Right.
Even though they might not actually start renting until the next
right,
license.
you're right. So we'll work on number 3 for
Okay.
second reading to qualify that if you got your license so close to the end of the year that you could not possibly have made 28 nights.
I'm sure there's a better way of saying
Yeah,
it.
well, yeah, that's a good.
You need to get an
that's a good point.
advertising pass.
Can it be a year after you get active license?
Well, we'll always tie it to the renewal, so that, to discourage having to do it
Well, you can
mid-year.
say you have to prove you've rented 28 nights the first full year of your license.
Yeah,
Right.
we'll-
That would do it.
No, the second year.
Yeah, we'll tweak it.
The first.
First
year.
full year.
Yeah. Okay.
All right, thank you, Wes. Retroactive inheritance ISTRs. So last February, City Council amended the ordinance to allow anyone who inherits a property from the person who owned it when the referendum passed to get a license. That amendment had no other effective date other than the date of the amendment, which was February 2024. That covered anyone who inherited a property after February 2024. What we found out just a few months ago is that there are some folks who inherited the property from the person who owned it when the referendum passed in 2023, prior to us passing the amendment. And so this is a question we want to run by council and make sure we understood your intent. This proposes to allow anyone who inherited after the referendum passed and before the amendment passed to come in and apply for an ISTR. This is basically applying the inheritance ISTR to those folks who inherited between the referendum and the amendment. We want to make sure that's council's intent to allow those folks to also get a license, not just people who inherited after the amendment in 2024. Is that how you guys?
That seems fair.
That's how I
You
understood
cut
it.
out a year and a half stretch.
I think that's reasonable.
And there's a note here that, I've got May 1st, 2025, that's the next business license renewal. So that those, and right now, I only know one family who's in this situation, because those are the ones who contacted us and kind of prompted this amendment. But that does say that if you inherited it in the year before the amendment, you can renew any time up until renewals next year. So it gives you basically almost a full business license year to do your research, make your calls, get this information, and apply for a license. All right. Standalone medical hardship investment short-term rental license. When we amended ISTR last year, we kind of lumped together the inheritance and the medical hardship exceptions under the definition of investment short-term licenses. In practice, the medical hardship license has a certification, annual recertification that's necessary in order to renew. An ISTR is automatically given the ability to renew as long as it remains in good standing. Medical investment short-term rental license has to do an extra step and recertify their hardship. So we thought it was best and cleaner just to pull that definition out. So the next 1, 2, 3 slides are basically just reflecting, rearranging the ordinance to make medical investment short-term rental license a separate thing. So this is striking it, and the next slide is new language, which is the exact same language carried over to a new definition, and then the next slide is working it into the list of transferability. Medical hardship investment short-term rental licenses are not transferable, and they do terminate if they're not recertified. If the lease or other factors that were sent in to qualify for the medical exception no longer apply, the license will be revoked. So if you send in a lease that you were in assisted living, and next year you move out of the assisted living and you don't provide any other paperwork to renew it, will qualify it. Or if the person who qualified passes away, the license ends upon death. Now, I wanted to throw that out there for you guys to consider. The upon death, it's possible that someone with a medical hardship license will pass away mid-business license year, early in the business license year. Do you guys want to terminate the license when that person dies, or do you want to allow the family or the state to rent through the end of the business license?
I would say not to renew.
I would say not to renew, keep it going through. I mean, when something like that happens, especially with, seems like somebody's gonna be a patriarch or matriarch of a family, there's gonna be a lot that other people have to figure out and deal with and get organized on.
So we let them finish it out?
So they're gonna finish out the.
And it's like, it's not gonna happen that often.
It should hopefully be a rare occasion, but we do want to have clear guidance.
Well, Stacy, there's only 2 right here?
There's only 2 right now.
I think that's fair.
All right. Next up, we have partially rated structures. So,
Wait a minute, let me ask you a question. So, I hope this don't conflict with anything we've tried to do before. So, if I kick the bucket, they can run until the end of the year, but if my probate's done within that time, then the license is gonna change hands, so the license is dead once it changes hands.
right, but your heirs can get a new
If
license.
it's my heirs, but if they just sell it to somebody else.
Yeah, it just,
Yeah.
yeah.
Okay.
So a
So
new
as long as we're not
owner-
gonna conflict with ourselves
New
later on.
new ownership will always trigger a new license.
There you go.
depending
That's-
on the old
Everybody understands that. That's all I'm saying. Just, because if you write in here, it runs to the end of the term, somebody's gonna argue with you, well, that license is good to the end of the term. I mean, 'cause unless you put in there, unless ownership changes hands,
Yeah, well,
something like that. So somebody's gonna come back and argue that point, I guarantee you, somewhere.
I do believe. Next up is partially rated structures. So the entire ISTR, OSTR structure is based on 4%, 6% properties. There are cases where someone has a structure that is their legal residence, is given a 4% tax rate, but is also given a partial 6% tax rate. So technically, they are legal residents, so they're an OSTR, but they're also an ISTR because there's portions that are rented at 6%. And when the referendum first passed and we were operating with the language as adopted, it was unclear how we would address those. And so at that time, we made the policy decision to tell those owners, you've got a split tax record or tax class, you can rent 6% on an unlimited basis. And as long as you don't entirely lose your 4% rating, you will still be an OSTR, but you're exempt from the night limit as long as you just rent that portion of your property. Last year during the amendment process, we decided that going forward, which means renewals that happen this year already and beyond, no matter what partial rating you had, if you have any 4% rating at all, we're gonna treat you as a full OSTR, and you can only rent for 72 miles. So there are a handful, but I don't know how many, it's not many, it's fewer than 10, that we know of that were licensed in 2023 as partially rated structures, and we're told you can rent that unlimited, and there are notes in the file. But for everyone that renewed in 2024, or new ones beginning in 2024, and onwards, the entire property is limited to the 72 night limit. So there's no more using the 6% partial rating to get around the OSTR rules. That was the intent when we amended the ordinance. It's documented on the record last year, but the language of the ordinance just wasn't super clear. That is licensed after February 7th, 2023. Just expanding a little bit to make it abundantly clear and explicitly stated for people who want to know. Any questions on that one? All right. And this is just another kind of housekeeping one. We've got the list of rental rules. We debated at length which ones should apply, which ones are rental related, which ones are general city regulations that we want to notify people about, but not necessarily we can cite them for rental. So rental rules and general regulations has been adopted as a definition to replace a lot of other words in the language. In the certifications, basically in the certifications section, that list is repeated over and over and over, including references to summaries of that list. So we just condensed that into one thing. This is, and I apologize, I don't have it handy, but this is paired with something that's not on the presentation, but it's in the ordinance. Just making it clear that citations for violations on the rental property are what count as strikes. If your tenant goes down to Center Street and gets in a brawl, that's not a strike against your license. If your tenant is out on the beach with a objectionable inflatable raft for a bachelorette party, that is not a strike against the license. If your tenant is driving a golf cart after night, that is not a strike against the rental license. Rental strikes only come from violations that happen on the property. All those things are real things that happen, but the ordinance says related to the use of the property as a rental. So we don't believe we can hold the rental properties accountable for tenant behavior off the property, on public property, away from the rental home.
But can we hold them accountable for the behavior on the property?
Yes. Anything that happens on the property that results in a citation will result in a strike. But we had some inquiries, why were properties getting strikes when their tenants were misbehaving away from the property?
So the tenant deals with public safety, but then the owner gets the strike because there's,
No, the tenant gets the ticket and the citation, and then the strike goes against the license. So if you have a tenant that's noisy and loud,
or,
and public safety comes to the property and writes that tenant a ticket,
mhm.
and then that ticket goes to court and they're found guilty, the owner or the agent will be issued a strike. The license gets the strike. Strikes go against the license. They're not necessarily issued against the owner or an agent. Citations go to people.
Right.
Strikes go against the
So the
license.
citation would go to the person if they violated an ordinance or a law?
Right.
Okay.
And in the ordinance, it says that tenants, agents, owners who violate the law, if any of those people get a strike, a citation, and are found guilty of something related to using the property as a rental, strike goes against the license.
Got it.
All right. Next up, advertising equals operation. Throughout the years, we've been prosecuting some of these cases, especially renting without a business license. We've had various folks come and say, well, I was advertising that on Airbnb, but just for my friends. Or I was advertising it on Airbnb, but I haven't made any reservations. Or gave it away for free, I just use Airbnb for scheduling. The judge has found, and we agree, that advertising your property is by default operating that property as a rental. They're one and the same. If you advertise a property as available for rent, you are subject to our short-term rental ordinances in relation to that property. So throughout the ordinance, you'll see a lot of advertising or operating inserted. We've tried to break down the violations, so it's explicitly clear that advertising and operating are the same thing. If you advertise a property without a license, that's the same as operating it without a license. If you advertise a property with a maximum capacity of 500, that's the same as operating it as a max capacity of 500. So we just wanted these minor language amendments, just so folks reading the ordinance really understand that, hey, if you advertise it, you need to have all your paperwork in order just to do that.
And then, how do we hold them accountable? If we can't give them a strike, we can't, I mean, we don't have,
Right, so right now, when you're guilty of renting without a business license, you get fined a $500 ticket.
and then,
In theory, that can be applied every day. So far, we haven't issued any multiple day citations, right?
Not yet.
Not yet. So we've had a handful of folks who've been found guilty of licenses, and then they're subject to regular reinspection by the STR folks who go by there on the weekends, who go by there during the week. They knock on the door, they harass elderly guests. But once someone's been convicted of renting, it's our duty to monitor the property. So we haven't gotten any of the multi-day tickets, but I imagine that as the next step of enforcement, if you've been busted last year for renting without a license and you go back next year, then we'll start issuing multi-day. I mean, because the reality is until the fines get substantial enough to be punitive, $500 a month is just the cost of doing business. But right now, the only penalty for renting without a license is your ticket and prosecution in court. You are removed from the wait list.
okay, that was the next question.
So
Okay.
you can't,
So you jeopardize.
you can't get a license, because you can't get a license unless you're on the wait list somewhere.
So they'd be pulled if they were on the wait list.
And that's it.
Good.
But some folks are always gonna choose, well, I'll never get a license, I'll just keep getting this ticket.
Right,
We haven't gotten there yet.
okay, thank you.
Next, yes. Final certificate of occupancy needed to rent. So this came up at least twice. When Eric goes to give a CO, sometimes he gives temporary COs when the things that need to be remedied are not life, health, safety issue. Of course, now I'm drawing a blank and he's not here, but there are cases where you can get a temporary CO for something that's not, your landscaping or tree mitigation isn't complete, that sort of thing. And so we had folks apply under temporary certificates of occupancy, they got licenses, and then their temporary certificates of occupancy lapsed. And that technically triggers the whole process of, now we need to revoke your license, and then in 3 months, you get your final CO, and them coming back and saying, well, we have a CO, we have a license on the staircase in the side yard setback at property on Indian, which you guys might remember. That was the case where they had a temporary CO, they got a license, and then they ignored the order to mitigate the stairs, and we were in this weird 6-month period where they were appealing to the BZA. And what do? So just to make it explicitly clear, eliminate confusion and streamline future issuances of licenses, we're asking to make it conditional on a final CO. There are no outstanding issues with that property. And the final CO never expires, like a temporary CO does. Any questions on that one? Okay. Maintaining licenses for replacement units. This is honestly a case where I feel like it's gonna be so exceedingly rare that we are legislating for the exception, but also we literally have a request to do this, and we have no means to do it under the current ordinance. So we want to know if you guys, how you guys feel about it. Right now, the ordinance allows someone to tear down a house rebuild it exactly as is, well, not even exactly as is, just with the heated square foot and bedrooms. As long as they still own the house, it's on the same site, it's got the same number of bedrooms, the same number of heated square feet, they can get a license for the new building. Well, we have at least one owner who owns more than one property, and they'd like to pick up one of the houses they own that has a license and move it to another lot that they own. Same house, same owner, just a different lot. And we're proposing that that has the same effect as if they tore it down on site and rebuilt it. And we'd like to see if you guys would be willing to let them apply for a license. The house meets all the requirements, it's the same heated square footage, it's the same ownership, it's the same number of bedrooms. It's just been moved, it's the same ownership, it's just been moved to a different lot, or proposed to be moved to a
You're
different
just
lot.
saying that the license follows the building. So when they move the building off site A to site B, the license follows it to site B. Site A cannot get a license,
Correct,
no matter what they build there.
correct.
You can get on the waiting list, but that's it.
Right, yep. Only the license for the structure, and I don't even think I would use the term follows the building as much as they can apply for a new license and be exempt from the cap. Because they've essentially rebuilt the house with this, all the same qualifications, just in a different location.
I think if you want to do it that way, I think I would tie it to the building. So you're gonna move building C from lot A to lot B. And if that lot meets all the same requirements and setbacks as lot A did, then you're just saying the license followed that building to lot B. But on lot A is out of the picture.
I think we can word it to say the building is the same building, but I'm very hesitant to introduce any language that says the license is attached to the building, just because of all our legal cases, that particular language is problematic. But we can write it such that it
So-
says the same building is on a different lot.
So when I move it, I go in and redo the inside,
That's fine.
and I do 6 bedrooms instead of 5 bedrooms.
Right, and so this would require that it's the same, you can't add the number of bedrooms. It's not on the sheet. Go to the next, will you go to the next?
It says the same number of bedrooms and the same heated square
Yeah.
feet.
So it couldn't change.
So yes, it still says, the house has been relocated, but it still has the same number of bedrooms and the same number of heated square feet. So it says that.
I think the mayor's saying though, if you tear it, like if you had a shack and you have a license and you tore it down and then you rebuild on another lot, a house that's the same bedrooms and the same square footage, can the license follow the torn down house to the newly rebuilt house?
Not right now, no. So currently today, tear down, replacement on the same lot, license them. You can get a new license. Tear down, replacement on another lot, you can't get a license. Move one to another lot, you can't get a license. So we're proposing, move the exact same house to another lot, you can get a license. Not, you can tear down this house and rebuild it over there.
Okay, so when I move this house to another lot, and I get halfway there, and because of termite damage, I lose a third of the house, and I go, damn, now can I fix that house? Can I go back and remodernize that house? Because now it's not, so is it the same number of square footage and bedrooms that show up at the lot, or is it the same ones, there's all kind of things that could happen in moving a house that you never know
That is
about.
true. So,
Seems to me the easiest thing to say is no. It's gonna be a different tax ID number, it's gonna be a different PIN number,
yeah, it's gonna be on a different
it's not
property
the same
completely.
property.
All right?
It
Any
might
other,
be the same 2x4s, but it's not the same property.
okay? Any
But the
other-
advantage of it, I think, is you gain a rental license, because they have 2 currently, they would lose 1, so.
No, they don't have 2, they only have 1.
You only have the one.
They got 2.
Well, this particular one has 2,
Well,
but hypothetical could have 1. But, we do get a lot of feedback about our prohibited floodplain management, other policies that discourage people from saving old Folly cottages. We've already done it with the tear down and rebuild, so I don't know if this would make it, honestly, now that I think about it, I don't know if this would make a difference or not. But,
I just don't know how many people are gonna be moving houses. That's a,
So far, there's one.
Well,
Yeah.
I guess.
Well, I can think of two other houses that got moved, but they always changed after they got moved,
Right.
because they had to in the move. It's like, oh, well, damn, that got tore up, so now I gotta go change this.
but I think if you
and
put
this
it in
and
there
this.
where they can't change it, the square footage or the bedrooms, then,
Well, that is in
That's what it
here.
says.
yeah, that's what I'm saying, that's what it says.
And Mr. Farley raises a good question. If we let them move it, should we also just let them rebuild it from the ground up on another site?
Well, that's just transfer of a license then from one property to another.
You can't do that.
Right, that's what that would be.
I think Mr. Farley's answer is the easiest one, no.
All right.
I guess my only question was for Attorney Wilson, as far as if you had any feedback on this, or if we're taking any.
No, I do, I mean, there's been some arguments made, and I don't think they're problematic. Let me make that clear, but there have been some arguments made in these appeals that somehow or another, if you attach the license to the house, that makes it a zoning change or some sort of thing that gives them a vested right or something. But it's not even well-defined argument, you know? So I don't know that I have a whole lot of concern about it, other than the difficulties y'all pointed out in
Okay.
trying to get a circle around what you're doing.
So you got two houses, so you move one, is it on one lot? Is it two houses on one lot, and a two-family residential?
So,
And so when you move, let me just think fast forward a little bit. So if I go and move the smaller house to another lot, then does that give me the ability to enlarge the remaining house?
so it's two houses on two different lots.
Okay,
This particular situation is two houses on two different lots.
So it's two houses on two different lots, and they wanna move it to a third lot.
Yeah,
No,
No, they want to tear down one, lose the license completely, and rebuild their own new home. And then they want to move the other place. Okay. They want to move this lot, this is called the oceanfront lot, the house that has a license on the oceanfront lot. They want to move it to the, across the street lot, maintain the license. The second row lot, they're gonna tear down that house, rebuild it over here, but not get a license. So you'll be losing the rental license, because they're both licensed
Yeah.
right now.
but
They
then
understand.
you merge the two lots that were congruent, you merge them into one PIN number, and then you can add on to the remaining unmoved house.
Well, these particular lots are across the street from each other.
They're not next to.
okay, so just to
Well,
start,
what they're doing is they're trying to move a rental house to an empty lot to keep it a rental, so they can build a McMansion on the front beach lot.
Which there's
There's nothing new, but I'm just saying that's what they're trying
And
to
there's
do.
no restriction from that.
No, it's not, but,
Yeah.
but,
That's
but
their
the question
point.
is, are you gonna let them keep their business license by doing that, by moving it to a different place?
you know, honestly, after now hashing it all around, I don't have that big a problem with that. They're taking a cottage theoretically, okay, moving it, same size, same everything, they already have the license, it's no extra license. They move it to an empty lot, and then they build whatever they want, they don't expect any license, that's,
Yeah.
am I right on that?
yes.
That's
you're
correct.
Yeah, that ain't the problem, what they're gonna build,
Yeah.
they just have to meet all the other regulations.
In this
Yeah.
case, it would be a net
I'm
loss
okay
of
with
the license.
I think it's beneficial that we
I think
get,
it's okay.
we
I
get a
think it's-
license out of it.
That's right.
I think it's fine.
Well, what we can do is we'll further study it for next month and address the idea, because as Mayor Mr. Farley pointed out, if they get it halfway across the street and it falls apart, can they just rebuild it on the other lot and still get a license? It's the same house on another, is that the same? So we'll mark that one down for further study for next month, if that's okay.
Show me a picture of it, so we, show me like the satellite map of
We got a cartoon.
of where it is and what it, you know, what we're talking about.
And then, Wes, will you, go back a slide to maintaining the license for replacement units? Just wanna point out here, item A2 here. So we already have the amendment in place saying that if you have a license and you tear down the house and you build it with the same square footage on the same lot, the same number of bedrooms, you can get a license. But we want to make it abundantly clear that you cannot let your license lapse during the process. We are semi-dealing with this issue with a case now where someone, even though they violated the heated square footage, there's an argument that they had a license, why can't they get a new one? And we just want to make it clear that if you have a rental license and you plan on taking advantage of this and replacing the house on site, you can't let your license lapse in the meantime, because if you let your license lapse,
You don't have a license.
you don't have a license anymore. So just want to make sure everybody saw that. All right, thanks, Brent. Then one more. Okay. Failure to timely renew a business license is grounds for denial. So last year, during the winter months, we had extensive debate over how late your business license could be before we moved to revoke it or deny your application, and we settled on 10 business days, which is 14, works out to be 2 weeks. So this year, we've denied folks for being more than 2 weeks late for their business license, and we just want to reiterate that language here in the code to make it clear that the penalty for missing the 10-day grace period for your business license is the denial of your renewal. That's just to strengthen the notice given to folks that if you are late with your business license, more than the grace period, we will deny your renewal application.
And that's with all the appropriate paperwork, everything's in,
Right.
everything.
Yep. And the business license has much less paperwork than the rental registration. But we have the existing language that says to remain in good standing, you have to submit it no later than 10 business days. This is just reinforcing that. We will deny your license if you are more than 10 business days late.
But the agent can act on that too. right?
Oh, yeah, yes, sir. And often it is the agent's action or inaction that
Create a
generates
problem
these
in the first
discussions.
place. Yeah.
And was it on the rental license that we talked about? Somewhere it said strike,
Yeah,
and
we're
somewhere
going,
it's.
that's the
That's coming.
that's the last thing. We already talked about this, the OSTRs are exempt from the minimum night rented, just because there's a lot of administrative paperwork to confirm that, and it's really not necessary for OSTRs, because there's no limit, and they can be basically renewed at any time, as long as property's in good standing. So, next up, on the order of application for license and rental registration. So, our rental registration chapter started in 2011, it was amended in 2018, it's been amended multiple times through there, and at some point, we said that the rental registration had to come first, and so we want to make it now that no business license. This is incorrect, and I apologize. We want to flip the order, so that you have to get a business license before you get a rental registration. I realize that's not what that says on the screen, but we want the sentence where it says no new business license shall be issued prior to the approval of rental registration permit. We want to flip that and do the business license first and then the rental registration permit. And then in addition to that, we want to make it really clear that your rental registration permit application must be complete, it must have all required documentation, and it must be in 30 days of the business license. That's either for a new license 30 days after, or for a renewal, which is 30 days after the renewal period. All your paperwork has to be in. This year, the first year of full implementation, our staff worked hard to fulfill the mission statement of Folly Beach, which is to provide professional, courteous service that complies with the law, but still offers that hometown touch. And what that meant was, hey, Mr. Pope, we got your rental registration permit, it's in, it's submitted. Oh, by the way, we need your parking diagram. And Mr. Pope doesn't get them the parking diagram for 3 more months. Going through all of the appeals, I think we now realize that, unfortunately, that friendly touch is just ripe for challenge, it's ripe for accusations of unequal treatment, it's ripe for accusations of staff manipulating information after it's been submitted. We do not want to be in the business anymore of touching a rental registration permit application after it's in. You submit it, you have all your paperwork, we'll process it if it's correct. You submit it, it's incorrect, or you're missing 3 of the 5 required things, it's denied, and you need to come back and try again before the end of it. We're gonna fix the application so you actually can't submit it unless you at least upload something.
So what happens after it's denied?
Then they'll have to appeal the denial. It'll trigger a whole new process.
Okay.
But we felt like this language was needed just to drive home the message that we're not responsible if you do not submit a complete application.
I think it drives home the message that we're not responsible, and we're gonna treat everybody like everybody else. Everybody get treated fairly, everybody get treated on the same line, and as long as we treat everyone exactly the same, people complain, but unfortunately, that's the way it goes.
I don't know, that gives me a little bit of heartburn, because I think there might be opportunities where people just make a clerical error. It seems like if they get in on time, and then we say, and it's not right, and then the deadline passes, and they come up and they say, it seems like we should have like if it gets sent back, you get 10 more days to get it in, and then after 10 days, it's revoked. It just seems unnecessarily harsh that you lose your license because you screwed up and didn't attach your parking thing. That it should be like, you screwed up, you're on notice, the clock's ticking, you got 10 days or 5 days to resubmit, instead of the death penalty because you thought your wife attached the parking, but she didn't.
Okay, I hear you, and if you're gonna do that, it has to be, here we go again. You're gonna give them a 10-day deadline, and they're gonna come in on the 11th day and say, well, damn, I thought it was today, I didn't know it was yesterday. So what are you gonna do then? I only missed it by 1 day. You only missed it by 11 days.
You've been given notice though, whereas you think you beat the deadline, you handed everything in, and in your heart, in your mind and your heart, you think you did it right. But then you get told, that's wrong, we give you a 10-day grace to go get it fixed. And after 10-day grace, you were informed of what you were lacking, and you had 10 days to resubmit, to get it in, to do all that.
Yeah, but my wife turned it in, or supposed to turn it in. I mean, I can hear them all, again, I'm just
I mean,
saying.
they're gonna line up here, and I'm just saying, if we say you were notified and you had 10 days to make it right, and you missed that 10 days.
Wait a minute, they don't line up here.
They
The reason you.
will line up here.
No, the reason you hired a judge is so they line up in front of a judge. They don't line up here.
They will line up, they will wait here.
Yeah.
They will line up at public comment. And my other question is, if we make them get business license, what's the lag time? Like, you apply for a business license, how long does it take to get? I know residence license are longer to issue once they submit, or how long's a business, like, you get it the next day, or you get it like?
As long as it's not during renewal season, which normally a new one is not, it takes no time.
No time, okay,
I mean, literally, they can get it that
Perfect.
day or the next day.
that's great.
What if
And
we're
this is
jammed
30
up?
and this
What if
is-
we're jammed up, to Bill's point? What if we're jammed up and it takes us a while to realize that they don't have everything on the rental registration, and we don't tell them until the last day? And then they have no time at all to get the document done right. Because I see what he's saying, if we deny them because of something like that, there should be some sort of window there to cover us, because like she just said, during rental registration period, we are jammed up. So we're not getting everything back to them within 30 seconds.
Right.
You know.
It is within 30 days of the issuance of the license, but we can definitely mark this down for further discussion next month or even later this evening. There has to be, whatever it is, a 10-day grace period. 10 days after notification, there has to be some
Drop dead
dead
date,
day.
yeah.
And
I don't think if you say 10 days, that is a drop dead date, but at least if we're backed up, we don't put, it's not our fault, because then that's what they're gonna say next. Well, it's your fault. I didn't find out until just now when I submitted my application to you a week and a half ago.
I actually think that, we've had a long, nice year of hand-holding and being very kind and educating and things of that nature. And I think as we narrow down and we start to get out of sort of the individual cases, I think it is important that we just make it black and white, whatever we decide. And so adding another extension, that just sort of makes it grayer for me.
I think the problem too, if you come back after your 10 days, whatever, and you don't have everything you need that second time, then do you get another 10 days? You know what I'm saying? Just-
No, because the first time you would
You
have
get
given
one
notice
shot
about
at
it. You're deficient in this,
You don't know what you don't have, you get 10 days to turn all this in, or else you lose your license,
right.
but you have to have some sort of time period, because,
No, I
and
understand.
I'm more worried about our side being jammed up, because that's all I hear during that time, is that our people are swamped. That's the time where they're just, that's their busiest time of the year. Well, if we get jammed up and we don't tell them until the last minute, oh yeah, we need this and we need it in 3 hours, well, that's not right.
But then, but that swamp time, these are known entities now. Now we know what we're working with. We have now, I guess, a history where we have our arms around. These are not new things to be able to predict in that sense. So I actually think that being more proactive and helping people along the process led us to the path to be more black and white and say, this is the deadline, so on and so.
And that is exactly what happened, and that is where this is where it's coming from. It sounds harsh. It's the idea of, this is the application, this is the documentation required. An application that does not have the documentation required is insufficient, it's incomplete, it's denied. Versus your application, and again, we'll definitely bring back some language, but versus, this is your application, it's insufficient. Here are the 4 things you have to get to. Now we're gonna leave this case open for the next 10 days. In the middle of all that, and there's 17 different things open at different stages waiting on. Has Mr. Smith met his 10-day deadline? Oh, Ms. Jones got it in 11. It creates the order, the complexity just increases by orders of magnitude every time staff is not allowed to say, this is wrong, it's denied.
Is it possible that you could hand your application in 3 weeks ahead of time and not be notified until 2 weeks after the deadline that you were deficient?
I think this year, that could have been a possibility.
Yeah, how many-
Is that a possibility
so.
in the future? Then we should correct for that. We shouldn't.
If that's a remote possibility, we should correct for that, because that is on us, and that's why we get called, and that is a problem on our side. We get, oh, you're just there rude. No, man, you gotta give people some sort of grace period. You can't, I'm sorry, these guys are too busy for that. And they don't have to check in on a daily, I mean, everything's time stamped. If they send a message on the 10th saying, hey, you got 10 days, they don't have to look at that account again until the stuff comes in.
How many?
I mean, it's not like you have to look at it every day and do work on it.
How many insufficient applications have we come across that have lost their license in this?
No, nobody lost them.
Nobody?
I mean, everybody had the chance to fix it.
So we haven't denied anybody because of late paperwork currently?
Well, we have
I mean,
40 cases
40,
not
we got 40 cases?
not
pending right now.
Pending,
insufficient.
40 cases. So apparently there's
None for being
some
insufficient.
communicate, and I think I've read some of them, there were
It's
communication
a mixture.
issues.
It wasn't because of insufficient information, it was because they didn't submit it
Okay,
on time.
on time.
Which are
That's two totally different
very
things.
different,
Okay.
yes,
How,
sir.
how many did you guys have to go back and forth?
I would say half at least.
Half of the ones that applied,
Half of all of them.
Half of
half of all of them, y'all had,
Yeah,
good God.
Chase people.
And how many,
and-
on average, how
Wait a minute.
many times do you have to follow up?
Many,
Probably
a lot. People,
average 30 times.
and to your point, sir, you cannot submit a rental registration and accidentally forget a parking plan, because it has to be uploaded. So if you upload Mickey Mouse's face for your parking plan, you're actively choosing not to upload it complete.
She won't let
I
you
mean,
upload
it
till
will
all
not
the
let
things
you-
are, all the
right.
things are
Okay.
included.
Last year, it would let you do that. Is that what you were saying earlier? The form, you're making it
It
mandatory.
would not let you.
Okay.
But a lot of people just uploaded whatever they wanted for ATAX that had nothing to do with ATAX. But then they said, we turned it in.
So we'll bring this back next month with some options that are noticed. But how about,
Sounds good.
does everyone, is there a general consensus that if there is a response time in 10 business days is a good standard?
That's plenty.
No more than that. That's on the outside of reasonableness,
I like it.
in my opinion.
All right.
Yeah.
We'll have that one back. Rental registration refunds. So the business license ordinance,
Run that.
I don't know why they go back and forth so much.
Wait a minute, hold it. Let's not have one conversation at a time. The reason they went back and forth so much was because they was trying to help people get through the process this year. So they were trying to hold their hands, get through the process, and still we had people that didn't turn it in on time.
I understand, that's what we're just talking about, if they get 10 days from the notice of being defunct or something's not right, then that 10 days, and that should be plenty of time.
I think it's-
There's no reason for them to go back and forth every day on it, if they have a 10-day notice of what they're missing, you don't have to talk to them again for 10 days.
What Aaron's saying is they're all gonna come in, they aren't gonna get them all the 10 days thing at the same time, so they have to keep going back to see who is, what day. You're due today, he's due day after tomorrow.
We got some of the most expensive computer programs and things I've ever seen in this municipality. We don't have anything that can regulate that a little easier.
I'm not saying that.
I mean, I'm just saying
This man
that's,
can answer that
I mean, there's a better way to do things, I promise you, if that's the way you're doing. If you're doing it with pencil and paper, there's an easier way to do it.
You got to be able to manage the time that things come in, you know, because you're gonna be back here, somebody's gonna miss that 10-day slot you give them by 2 days because my wife forgot to upload whatever, and you'll be back again saying, well, you know, it's just.
They're done.
No, the
Okay.
10-day letter gives them time.
Hang
to
on,
resolve it.
hang on, I'll,
I can say the same thing about half the things we've talked about tonight, but there's no
I bet
point
you.
in it. I mean, come on, slow down.
Yeah, I'm just saying.
So this comes back to us.
Oh, yeah, that's what.
yeah.
So,
If you don't have it on, and we tell somebody 2 weeks after the deadline that, oh, your registration was lacking something, and they lose their license, then we'll send them to you. I mean, you can easily do it that way too. I mean, it can go both ways.
I bet you, send them to me, because I bet you, if I was lacking in my license information going to the city of Charleston, I don't care when they sent me to denial, it'd be denied. I'm sorry, that's just the way it is in the world, other than small town politics.
No.
Yeah.
No, if I don't fill something out of my alcohol license, they don't take it away from me. I pay a
see.
fine and I redo it.
Well, out in the world, so.
That's
I'm
out in the world.
gonna give you 10 days and a $500 fine to get it fixed.
And I'm a fan of finding people, and that is yet to come up, because we're gonna bring it up later on.
Put that on your
Mess it
notes.
up, fine.
For next time.
I have no problems with that. I mean, you just you tax them, you tax the shit out of them, but you don't take away their entire business from it. That's the way of the world. You make money on stuff, you tax them, you charge them for their errors, but you don't just completely get rid of the business.
So in addition
Like a
to
bookie,
make-
you wanna keep them bleeding them.
So in addition to maybe the extension of 10 days, they get a
Say,
fine?
yeah.
That's on the table?
We'll bring you guys back some options.
Okay, sounds good.
So next up is rental registration refunds. This is a gray area in the code. Our business license ordinance specifically states that business licenses are not refundable if the licensed business ceases to operate. So if you come in and you get a business license to sell snow cones, and it's a freezing cold summer, and you decide, I'm not in that business, you don't get your money back. We had a few requests this year for rental registration refunds for people who had midstream decided they no longer wanted to rent. It's just not addressed in the code right now, so we're proposing to make the rental registration refund language match the business license refund language and say, once you pay it, you get licensed to be a rental, you paid it, it's not refundable. If you stop renting, that's your business.
How many of those complaints for people who run in here and got an ISTR license before the vote and just decided, oh, I don't wanna have to pay that $2,000 again to keep that license up?
I don't know. This,
That was the whole intent of our action.
There you go, yeah, so.
Thank you very much.
any questions on that one? All right. Rental registration information changes. This is just a symptom of the evolution of chapter 117. In the past, when rental registrations were free and all licenses, there was no limit on licenses and you could apply for a license. We had language in here that you had so many days to notify the city of a change in registered information, especially ownership information. These days, if your rental registration information changes in terms of the owner, that means someone's getting a new license, and so it needs to go through the whole process. So the net effect here is just to say that there's no fee, no timeline. If you want to change anything about the rental registration in terms of rental agent's name, the address, the email, et cetera, you can just email us, hey, my property switched from dues to Casa. There's no fee for that. But, if, sorry, that's my mom. She's exempt from my emergency taxes. There is a fee. If you're a new owner and you get a new license, you do have to pay a new rental registration fee, even if the last owner had one and paid it. So that's that. Any questions there? All right.
Yeah, why don't you check? see
Yeah,
what-
I was gonna say.
It's gonna leave me a voicemail.
Okay, well, we got
we
plenty,
got-
we got plenty of time.
We're
so,
fine.
yeah.
It's usually not.
Don't forget to call your mom, as
Sorry.
Louis Gazard would say.
Just call and say hello.
2%.
So these are the rental registration requirements, going through the list this year, as people applied, we needed certain documentation and we needed some information that's on the forms, but it wasn't codified, so we wanna make sure some of this stuff is codified. The parcel ID number, we've been asking for people for it, but it's not in the ordinance, so we're gonna require by ordinance the parcel ID number. Property tax bill or other documentation showing the current property tax classification. Right now, we ask people to write it down and then we go and search for that information, so this would shave 5 minutes off of every application by making them provide the current documentation versus us proving what they submitted. Amending the maximum occupancy to say they had to show us what they're advertising the maximum occupancy to be. The certification that the owner is aware that misrepresentation of information, that's an important one we wanted to add this year, just again as a reinforcement that everyone who does that rental registration reads, well, in theory, they read this sentence and they put their initials by it and they understand that if they misrepresent the information by listing the incorrect tax stuff as a way to, we bought the house 5 years ago, we never changed our property tax classification, but here's what we think it is. We tore down the house that had a license before, and we're giving you the floor plan of the old house and certifying that we're registering that house, not the new house. Those are things that happened. So just reinforcement that if you falsify or submit wrong information, that can be grounds for denying the application and or revoking the license. Not a strike, but revocation or denial. And then adding a certification for OSTR owners who kind of get off the hook for most of this stuff, but OSTR owner reading and acknowledging that they are limited to 72 nights. So that no one can say, I did not know that. And then also we're gonna ask people to report the 28 night, the total number of nights rented and prove 28 nights. We wanna know the total number of nights because we wanna know that OSTRs didn't rent more than 72 nights. We wanna know the number of nights so that we can get an idea of how many total rental nights there are on the island for planning purposes. We only want to prove 28 nights for ISTRs. Next up.
OSTRs are subject to revocation though.
Yes, if they rent
Rent for more than 72 nights.
we will move to revoke their license and report them to Charleston County, probably in reverse order, report them to Charleston County and move to revoke their license.
And then they become ineligible for another year.
Well, if they lose their OSTR license and they've rented more than 72 nights and the county changes their tax class to 6%,
Then they're subject to the cap.
then they're subject to the cap. So,
But if they go and get it changed back to 4%, they wouldn't be eligible for an OSTR
I
for
don't know
another.
how long it takes the county to reset property tax classifications if you lose it. I'll have to look into that.
They were doing it pretty quick a year ago, weren't they?
Yeah, I don't know, I have to research. And I believe it's gonna be at least a year, you know, I'll figure it out. Thanks.
Push that to the next calendar,
That's what we should do.
And if not, we can just write it for a minimum and say, you know, you can't reapply sooner than a year.
Right.
And then kind of the last one here, or the last amendment is the lack of timely rental registration permit. And this is the big one that kind of drove this year's annual review. And again, it's a symptom of the organic growth of chapter 117. In the beginning, failing to timely get a rental registration permit was a strike against the license. It's a violation which shall be considered a strike. When the cap got adopted and we rewrote chapter 117, we wrote it to say that failure to get a rental registration permit could be grounds, for revocation of the license. This year, we had approximately 40 people who never got a rental registration permit. We noticed all of them that we were gonna move to revoke their license. We were very quickly informed, hey, your ordinance has a contradiction. It says right here, you'll revoke my license. It says down here, this is a violation subject to a strike. So we paused all those hearings and we're coming back to city council to make sure we understand the intent and the will of council in terms of failing to get a rental registration permit on a timely basis. Is it a revocable offense or is it a strike? Or is it an escalating strike based on how, is this a special type of strike that would escalate the later it is? Or is it a 10-day grace period and then it's a revocable offense? We just need to know how you guys envision the penalty for late rental registration permits. The penalty for a late license after the grace period is revocation or denial. Penalty right now for a rental registration permit is up for you guys to decide.
If you're gonna get a license, a business license for renting a house, you know you have to have a registration permit for rental, a rental registration permit. That's, you know, so I don't feel like if you didn't get a rental registration permit, but you got a business license to rent a house, then it ought to be revoked. Because you know you're renting a house, and you know you have to have a rental registration.
I think it needs to be consistent with the business license language. Sure.
I agree.
This is another one of those spots where I'm good with the grace period, but fine them as well. We're doing if we do the strike instead of revocation, but then there should also be a fine attached with it. This way, just like an alcohol license at a restaurant. If I don't get my stuff put out on time and I have to do it 10 days late, there's a fine associated with it. And the later it goes, the heavier the fine gets, the heavier the penalties get. Then at some point, it's got to just cut off. I mean, we can't go, into months or anything, but whatever this is, it should be either you get 10 days, it's $1,000 fine, 10 days and that's it, or you go 2 stages, whatever, but there needs to be a fine associated with it to hammer the point home. And plus, if there's extra clerical work, that'll cover it.
Yeah, I'm with DJ on that one. I think the fine is a good idea, just to remind them to get both of them in.
I think the one that we just talked about, that we were just discussing about, if there's a discrepancy or something wrong with the rental registration, if we're gonna do a grace period for that, it should follow the same suit. There should be a fine associated with it. And if you wanted to match the business thing, I'm fine with that too. If the business thing follows it, but there needs to be a strike and a fine attached to it if we're doing things like that. That way, it covers us. We get extra from it. If it's their fault, it'll cut out people purposely, messing up to get an extension. Well, now we're gonna fine you for it too. And I'm not talking about $100 fine. I'm talking about $500 quarter fine. It'd be like, significant $1,000 fine or.
Well, I mean, the cost of doing business though, I mean, some of these houses are making so much money, the fine's gonna have to be so appreciable, I don't think.
The rental registration permit's a percentage, it can be a
You don't
percentage
follow
of
the
that.
business license, then you got 10 days and it gets revoked.
That's so there
I
is.
say, whatever, if they wanna match up, that's fine, but I'm in the impression rental registration, if you're over, a day or two, you don't lose it. There should be you get a grace period, you get a strike and a fine, and that's it. Where that falls into, that's for everybody to discuss, but I think there should be a fine and a strike attached to step revocation.
Well, you gotta remember, now, you're talking
$500.
about people that are renting houses that intentionally didn't get a rental registration.
But maybe not, maybe it's not intentional, you can't
Well,
claim this intentional.
You can't tell me if you get a business license to rent a house, you don't know you have to have a rental registration.
So what,
It goes
If it's their
together.
first time, if they're taking it over, if it's a new person doing it, we've heard several of these stories where the
And then
husband
you-
died, he handled all the bills, the wife's taking over, she doesn't know what was going on, cause he did everything. That's not a one-off story,
And
that
you
happens
better-
all the time.
and you better find somebody that knows what's going on if you're gonna be in the business. I mean, I understand, I hear what you're saying, but you know, you gotta take some responsibility.
Well, how does everybody else feel about what we're saying? Cause you two we're on opposite ends, but we're only two of us, there's seven of us.
No,
So-
I'm at opposite ends. Y'all said follow the business, y'all said follow the business license.
I said if you wanna follow the business model, fine, but I think there should be a grace period that involves a strike and a fine
No,
instead of
I
revocation.
think it's.
That is
a
what
grace-
I said
It's a
about
grace
it.
period if you follow the business license, it's a grace period of 10 days, and then you get a revocation.
I understand, that's why I said we're on different ends.
That was a big fine.
okay, so I'm just gonna dive in and ask if it's appropriate, I should wait till later on. I guess I would like some feedback from the hands-on staff. I mean, because that's really what I would like to hear, frankly. If we can execute some of these ideas, what's reasonable, what are you dealing with?
I feel like if you apply for a business license for a rental property, we're gonna tell you and give you the registration to fill out. You're not just gonna apply for a business license and you're not made aware of the rental registration. But if you are getting a business license to rent out a property and you come with us with application, we're gonna give you the registration to fill out and tell you, fill this out, here's the deadline. So I think it's very intentional when people don't do a rental registration.
Okay, and
yeah.
any other, do anyone else have feedback to that? Just,
My only feedback is we had a few people this year, and unfortunately, or fortunately for them, fortunate for us, I happened to overhear them say, oh yeah, I just uploaded stuff to keep them off my back because I knew if I waited long enough, they'd ignore it. So I do know that there is, I mean, I know for a fact a lot of it's intentional. And that was all because they weren't paying A-tax, and they didn't wanna get in trouble for not paying A-tax, and they didn't wanna go have to pay the A-tax, so they thought they could just milk.
see, I'm just trying to find the reason behind someone just wouldn't follow the rules. Maybe that's a naive question.
Because they don't wanna spend money.
Okay.
Well, then if
And
it's,
Carla, did you have anything
I
to?
mean, the rental registration is a hefty fee. I mean, it's completely different as far as like, you know, when you're paying your tax, when you're paying your business license, it's 2.75 per thousand. Your rental registration is $17.50 per thousand. So people sleep out, you know, that they make, oh my God, it's so much money. You have a business that's, I mean, I've seen the rents, I know how much they are. And it's a small portion to what they are. And, you know, some people, I had a gentleman come to me today telling me that, oh, well, I had, Vacasa was handling my properties, I didn't know. You signed the paperwork that said you had to fill this rental registration out. The rental registration, they have to initial it. It's not something they can get away with unless you know, the company's signing it for them, okay, fine. But it says, the documentation shows the business license, so the owner of the property has to sign off on it along with the person who's responsible for the property. So whether it's, you know, Suzy Q or, you know, Vacasa or whomever. So they've read it, or supposedly they have read it. This is not news. This is not something that they ignore, or they just blow through it and they go, to hell with the consequences, because they don't think that we're gonna hold them accountable. That's the problem, is there's no accountability for owning a business. And if you screw it up, okay, so what? I'm just gonna slap your hand, there's nothing to it. I know from personal experience, owning my own business, what the penalties are. I know what it costs. I ain't gonna do that again. They need to know that that's what it is, that there's responsibility. You have a responsibility to yourself, to your business, and to everybody else, to do it right. Pay attention. It's your livelihood. Yes, DJ? If it's your livelihood on the line, this is what I have to do in order to maintain my business, to keep my livelihood. You're not gonna forget certain things. It's just not gonna happen.
yeah, you do. And I can say when it comes to your business and all the different things, 'cause you have so many different things, like with my business, because since you asked about my livelihood, I have so many different taxes and licenses and different crap that I have to get from different entities, that one slips through the cracks very easily. And there's not one that says if I don't pay it within 10 days, I lose my ability to have a business. I pay a hefty fine and I get to fill it out and that's it. Thank you.
No.
There's nothing that says I
Okay.
lose it.
So this
You know
is,
what I mean?
we're talking about different than a business license, so how about 1 times the annual fee for rental registration for that piece of property?
I'm sorry, say that again.
1 times the annual fee for the rental registration for
One
that piece of
time
property.
annual fee.
The penalty?
You're gonna double.
The annual fee would be 17% of $1 million.
Right.
So it'd be your penalty would be 1 time the annual fee for that.
2 times.
I'm just saying 1 time, so if it's exactly the same, what you're paying is the penalty is exactly the same as you would pay if you'd paid your business license, your rental registration.
For what,
So now-
for what grace period? For a 10-day grace period?
10 days, 3 weeks, I don't care about the grace period, I mean, you
Well,
say
that's,
10
that's,
days.
that's what
10
we-
days is fine, and then just say, if your registration fee was $1,000, your fine's $1,000. If your registration fee was $2,000, your fine's $2,000.
So when it expires, do they get a
Out of
notice, like, if we're taking 10-day grace period, how are they gonna know they're in the grace period? I guess is my,
Well, the ordinance requires it to be due by June first.
okay, but I'm saying from the business side, so we're gonna give them 10 days after that. So I think from a bit, you're calling it a business, it is a business. So I think, to me, it's revocation, simple.
I
I sort of agree with DJ, we should sync it up to the business, and if we give a 10-day grace, we give these folks a 10-day grace,
Well, you give them a 10-day grace, but what happens after the 10-day grace?
then it's
Well,
revocation.
Okay, then I'm great
Then
with
it's
that.
revoked, but
Yeah.
they also have to pay
People should get at
twice the
least-
fee
People should
to get
at
in
least
that 10-day
one,
period.
one uh-oh, and you got 10 days to fix your one uh-oh.
So.
And you pay for it, and you pay for it.
There's a fine.
You know, you
Right.
say $500 for the mistake, or you take the revocation and eat it.
So the same thing happens if if a rental registration gets denied or whatever, if it's just incomplete, gets sent back, you've got 10 days from that notice of,
Same thing.
defunctness or incompleteness, or do you pay the fine? And yeah, that's
fine.
what I was getting at earlier. That's a far better way to do it than just merely taking something away from
It's
somebody.
not being,
Most
it's
of the
not
time it's
being
gonna be an
easy,
accident.
it's just being reasonable.
Right.
You gotta,
It's,
you just can't.
don't assume that everybody's out to scam the system. There are genuine mistakes out there, people that don't know what's going on and don't
Wait a minute, now,
understand.
we're talking, y'all talking in circles, because you keep talking about,
We're just bringing all of it up at once now.
I know, because you keep comparing,
matches.
rental registration to rental registration and not to the business license. So your business license grace period is 10 days. The end of 10 days, it's revoked. So if you want to make it the same as a business license, your rental registration grace period would be 10 days. At the end of 10 days, it's revoked.
That's what I
That
said.
means you're not renting a house.
That's what we
period.
just said.
We're good with that.
No, but y'all were you kept going around and around in the same, yeah.
That's exactly what I said.
That's exactly what I said.
Exactly what I said.
Ain't like,
Well,
nah,
where's the fine come in?
there ain't no
It
fine.
doesn't sound
It's
reasonable
your
now,
license.
so.
Why
I
not?
just, well, yeah, I guess that got thrown out,
Well-
out in bathwater.
We do, there is cost associated with having to do, going back, I would imagine, if we want to recoup that. I mean,
Not anymore. I think it's already been said. and
Well,
done.
I'm not opposed to considering a fine, not to throw it into the, I think accountability is important. Whatever message we send, I'm fine with the 10 days, it gets revoked. If we add a fine, I don't have a problem with that. I just think it's a level of accountability that we just have to send a message, whatever, whatever that is.
I think I'm hearing kind of general agreement to your registration is due June first. You can pay within 10 days, but if you do, you have to pay the $500 fine. It's a violation basically to pay late. It's a violation
Late fee.
to pay late. If you are so late that you exceed the grace period, you lose your license.
Yes.
So if you're 1 day late, you have violated the chapter. And the penalty for being 1 day late is a $500 fine, up to 10 business days late. If you're more than 10 business days late, the penalty is revoking your license.
that's perfect.
I'm fine with that.
We'll figure out a way to, I'll get with Joe.
That's harder than what I do.
Joe and I will talk and figure out how to word that and what we can do, but is that the general sentiment that due June first. You've got a 10-day grace period to pay it with a financial penalty of some degree, probably a $500 fine. If you're more than 10 days late, the penalty is revocation.
I don't really care for that, but whatever.
What didn't you like about it?
What's that?
What didn't you
I
like?
just, when you get into today's revocation, that's where I get a little iffy, just taking somebody's complete business away. I mean, certainly there needs to be a drop dead date, and I like the fine amounts, I like 90% of everything. I just, when you have an ability to completely take away somebody's business for something like an application not being filled out properly, that kind of bugs me, because I think about my business, if somebody did that to me, I'd be irate. You know, but that's not how it works in most other businesses. But that's the only part of it that really bothers me.
But-
I get it from every other aspect.
Mr. Rich, this wouldn't be for improper, we'll have to deal with that. This is for not doing it.
I understand, but there's just that is the part to me that is not treated like any other business out there, that I think is just a little excessive, but there's really no good way to get about it, and I'm good with 90% of what we just talked about, so I can suck it up, I'm a big boy.
All right. Next slide, Chris.
Are you coming back? Or-
So you just voted yes because of that.
He's gotta go check on his licenses, I think, real quick.
Okay, and then there are some organizational changes. There's a lot of red and strike through in the ordinance, but the majority of it is just structural things. We separated the medical requirements. We took the parking requirements and moved them all the way down to the end, to the general requirements for rentals, instead of describing them in the rental registration form. And then we kind of teased out all the strike language and condensed it to its own separate section under the violations. So when you see all that red, none of those things have changed. They've just been relocated. And then to directly contradict what I just said, we did clarify in the parking requirements that the parking diagram, we already require it to show the parking spaces and the septic system, to prove that the parking spaces are on the septic system. But we're also gonna require people to certify that they have protected the parking system, the septic system from parking.
I think that's a great addition.
Yep, that's great.
Chris? So that's kind of the summary of what we've got. Or were there any other, what I'm calling minor changes, word changes that are listed in the ordinance that you guys had questions about that weren't covered?
I like how you define notification. Made it real specific about the mailing or emailing or
Right.
to the addresses that are on file. It's not our job to find accurate ones.
Right, and
Whatever's on file is what we do.
and that
What
is
you
where
give
it
me, what
came
you
from.
get.
And also, we already require people certification. They in theory read and certify that they understand that mailed notice or emailed notice is valid notice. But we wanted to reiterate that, so that when someone comes to court and says, oh, I didn't get it, we can say to the judge, you know, they have signed and acknowledged that if we mail it and we email it, they have been served. That came up a few times, so we just wanted to strengthen that language.
I just have just a general question so that I further understand strikes. Okay, strikes accumulative or annual?
They're on a rolling annual basis.
12-month period, maybe.
So in 12 months, I can get 3 strikes, and then I can just hold there,
Now,
and then,
if you get 3 strikes, we will move to revoke your license. We have
Okay.
one of those this year.
okay,
That case is in progress.
okay, so if I have two, I can sort of just stay there, wait for the year to end up, and I start over again, and I can get 2 more.
If you get one in June and one in December, next July, you'll only have one on your record, because the first one drops off.
They're like points on your driver's license.
Okay,
They're absolved after a year. Just count.
got it, and then go to
You'll
confession.
have to go to confession.
Confession.
before.
You do realize you have to separate church and state here.
Yes.
All right? You guys need a break before we cover the remaining work session.
Yeah, 5 minutes.
Good idea.
Did the DJ go in his gun or what?
So, yeah, what he said was, you got 10 days, but if you're gonna be in a 10-day period to apply, you have to pay $500 to apply. And it's gone. Yeah, more than what I was saying.
That's